Good morning. Welcome to this session of GovDefender's Cybersecurity Virtual Forum. I'm John Nicholson. I'm a strategic negotiator with a company called Infosys, and I'm also the president of the DC chapter of the Cloud Security Alliance. This morning, I'm going to talk to you a little bit about security and legal issues associated with the adoption of cloud services. We're not so much going to talk about the technology, but we're going to talk about the legal issues, regulations, and other issues associated with cloud and security in the cloud. And then we're going to talk some about the difference between negotiating contracts with traditional outsourcing providers versus cloud services providers. So we're going to talk a little bit about where cloud is now. And I'm going to assume, given the nature of this conference, that everybody understands what cloud is and that I don't need to go into the NIST definition. If you're a little unfamiliar with it, you can look it up on NIST or ask the person next to you, and odds are they can give you a different definition of cloud from the person on the other side of you. We're going to talk a little bit about how secure data is in the cloud. We're going to talk about e-discovery and subpoenas in the cloud, contracting, and then some best practices for putting data in the cloud. So where are we now? Cloud has arrived. It was the concept du jour a few years ago, but now it's there. In 2011, there was $40 billion worth of cloud-based services. We're anticipating, and so is Forrester, that by 2014 it'll be almost $150 billion, and by 2020 there'll be over $240 billion worth of services based out of the cloud. The cloud has democratized the concepts of computing and storage. It is available to everyone, not just those who can pay for the hardware. It has potentially unlimited scalability. It has created pay-as-you-go commercial models and all kinds of new business possibilities, and it has become a catalyst for speed and agility and innovation. Cloud is really the biggest disruptor since the global delivery model, since the concept of offshore sourcing. We started with the idea of monolithic IT black boxes. With the idea of global delivery, we went to modularization of IT and an elasticity of skills. You could get any skill you needed from a provider, generally based at your location through a large outsourcing contract. And now we've moved to the idea of cloud inside global sourcing, where you can use the cloud not only to get elasticity of demand, but elasticity of hardware, elasticity of software resources, extreme scalability, and we've now seen a convergence of cloud, software, and business operations to create whole cloud-based business platforms. The cloud is going from the use of private clouds, typical virtualization technology to save some money, up to the use of hybrid clouds where companies are using private clouds, public clouds, some combination of proprietary cloud structures to solve all of their problems in real time. Right now, about 34% of IT budgets are being devoted to cloud-based resources, whether that's private virtualization or moving into a hybridized environment. All of this moving into the cloud and moving outside of the four walls of the enterprise creates a number of concerns. Standards concerns that are being addressed by different entities, technological concerns, particularly around security and data privacy, regulatory concerns, again privacy, but other compliance areas, and jurisdiction, because the cloud is ephemeral. Although there are data centers located around the world, the point of using the cloud is that it is irrelevant where those data centers are located. However, governments tend to view it a very different way, and they like to know what's in their country and what's flowing across their borders. So we have issues of data location, data sovereignty, discovery issues when it comes to litigation, law enforcement, and national security. So the essence of this conference, how secure is the cloud? When we ask the question, there are a lot of security challenges with cloud-based services. Many of the solutions in the market are silo-based, and those challenges exist when enterprises try to integrate their own private cloud with the public cloud for bursting and other on-demand services. as soon as you move beyond the four walls of your enterprise, you create a host of security challenges that people haven't necessarily solved. We have issues with security management between provisioning and deprovisioning, configuration management, data loss, data retention, data deletion, misuse of virtual infrastructures. There are issues associated with risk management, with different risk profiles, insecure applications, poorly designed interfaces. Data could get commingled by a provider. There are insufficient controls in many places. We have privacy issues associated with social engineering, PII leakage, social networking. Then there are all kinds of security assurance issues that others in this conference are going to talk to far more than I will. Recently, 2 years ago, the Ponemon Institute did a survey of 127 cloud providers, and most significantly, most cloud providers surveyed believe that customers buy cloud services because of lower cost and faster access to resources, and not security. Now, I've talked to a number of clients, and one of the things I talk to customers about is the fact that moving to the cloud is probably more secure than their own homegrown environment. Cloud service providers have a number of ways to protect information and regulate their environments that don't necessarily apply to most enterprises. But that may be a little unusual, and most cloud providers are not focusing on security. The majority of cloud providers have said that they believe it's their customers' responsibility to secure their information. Most cloud providers don't believe their services substantially protect and secure confidential information. Well, that's clearly a selling point for the cloud, is that cloud providers should be better at this. Most cloud providers do not have dedicated security personnel. Some of the biggest ones do. Your Googles, your Amazons, Infosys does. But at that time, a third of cloud providers were considering some kind of security solution within the next couple of years. So moving forward to this year, Ponemon did their State of Cloud Security survey, and this time they talked to 700 IT decision makers. Half of them now were evaluating security before they deployed. It was only 41% in 2010. Half of them are confident in the security of those services. 50% of them have done risk assessment before putting databases and other assets into the cloud. 50% of them are confident that they know all of the cloud services in use in their organization. And in other news, 50% of those people are wrong. 29% are confident in their ability to identify and authenticate users before granting access to cloud resources. And what they're starting to look at is this idea of a single sign-on, a hybridized access management program for the enterprise and getting into the cloud. And I think that's something that you're going to see in the future. That's really one of the next big service opportunities for cloud providers. So from a contractual and a regulatory perspective, how can you measure or require security from a cloud provider? Well, there's ISO 27001 certification, but just being certified isn't enough. You actually, as a customer, you need to review the statement of applicability, because that's really what tells you what things they're complying with and how they're doing it, as opposed to just that they're certified. You should also check the SOA against the Cloud Security Alliance's Cloud Controls Matrix. The Cloud Security Alliance has a fantastic set of tools that have been developed through a grassroots effort, and they're available for free, and they can really be used to help test your own security and evaluate how you're complying with security best practices. Then there's what's called the SOC audits. What used to be the SAS 70 Type 2, which was the only thing that customers could use to measure security, was really designed around Sarbanes-Oxley controls. It was really intended to measure the security and assurance of financial reporting, but it was the best proxy for security anyone had. Now the AICPA recognized that that was insufficient and really inappropriate, and so they've classified that as what's called a SOC 1, and they've changed it to a new standard. It's the SSAE 16 SOC 1 Type 2. And that still covers financial reporting, but there's a new test called the SOC 2, which tests controls at a service organization relevant to security, availability, processing integrity, confidentiality, and/or privacy. Not all of those might be relevant to a given cloud service, but the SOC 2 provides a way to audit that security. So why do you need to know? As a customer, you need to know how your information is secured and whether it's secured, and you need to know when it's insecure. And it's very important from a regulatory perspective because the SEC treats security incidents and data breaches like anything else that could affect share price. If the data breach or the security breach is material, the SEC requires you to disclose it, just like any other material event. Various US states, 46 at last count, plus DC, Puerto Rico, the Virgin Islands, and Guam, have data breach notification laws that require disclosure of certain types of data breaches within certain time periods. If you don't, your company could face penalties. If you're dealing with PHI, you have to disclose data breaches to the FTC or HHS, or you could face penalties. Various global data protection laws, like the EU data protection laws, require disclosure of data breaches of personal information within certain time periods, or your company could face penalties. So in addition to the typical security aspect of losing data or losing confidential information, you have this regulatory framework that's layered on top of it. And if you are a global company with global customers, you may be subject to different regimes, and you need to know if your cloud provider has lost information or has had a security incident. So let's talk a little bit about something that nobody really wants to spend a lot of time with, e-discovery and subpoenas. Litigation is a fact of life in the modern business economy, and it's treated differently in the US than elsewhere, but it's something that everyone needs to think about. I've talked to many companies that are concerned about moving to cloud-based services because they're concerned that their data might be somehow subject to a subpoena that was directed at the cloud service provider. So if you use Microsoft's Office 365, somebody could attempt to subpoena your email directly from Microsoft rather than sending the discovery request to you. If we're talking about criminal activity, that's a whole separate realm, and I'm going to assume that nobody in this audience is subject to criminal investigation right now. If you are, I suggest you consult your lawyer, and we'll leave it at that. But from a civil perspective, there isn't a lot of case law addressing the discovery of corporate email held by cloud providers, but there are some instructive analogs found in the Stored Communications Act and cases that are addressing the concept of control under the US federal regulations. In the US, the basic test under the federal rules of civil procedure is you can be forced to disclose information that is in your possession, custody, or control. And courts have construed control very broadly, but they haven't generally extended it to cloud providers. There have been some cases related to AOL email in particular where the courts have said the cloud provider is not subject to the subpoena, and then in certain circumstances they've looked to the next question and said, if this subpoena were directed at the actual owner of the information, would the owner have to disclose it? And then they've gone ahead and directed the cloud provider to disclose it because the owner would have had to. But the ultimate question was, would the owner have had to disclose it under US discovery rules? Even if the court doesn't force the cloud provider to disclose it, that just means the discovery obligation has come back to you. And the use of cloud services creates some interesting issues for discovery when under the US court system. Having data held by a cloud provider can make your compliance with discovery obligations a little more challenging. For example, what happens if your cloud provider loses the information? You put it up there in the cloud, they lost it, you didn't retain copies of it, it's gone, and you've been directed to disclose it by a court. Right now, most cloud agreements don't reference and don't have any provisions around e-discovery. And the legal analysis for what's called a spoliation claim, the destruction of data that's subject to a subpoena, normally focuses on possession, custody, or control over the data, which would point back to you as the owner of the data. The cloud provider's not normally a party to the litigation, and the courts are going to focus on the parties that are appearing in court. So if the court decides you are responsible for the data and you gave it to somebody who lost it, the court is probably going to order some kind of sanctions to balance the equities between the party that's seeking discovery and you who destroyed data that the other party needs for their court case. And sanctions can range from fines to a terminating order that just gives them the case. So what do you have to do? If the data was lost due to a cloud provider's actions, you're going to have to argue that it wasn't your fault. And that likely means going beyond simply establishing that they deleted the data. You're going to have to show you acted diligently in selecting the cloud provider, negotiating terms, putting controls in place, notifying the provider that they were supposed to save all of this. And despite all of that, the data was lost through no fault of yours. Now, judges are not necessarily technology experts. And as a lawyer, I can say that most lawyers are not technology experts. And so you're going to have a hard time arguing to a judge that it wasn't your fault that they lost your data. If you do get fined because the cloud provider lost your data, most limitation of liability provisions in contracts are going to prevent you from recovering those fines from your cloud provider. Then we have the democratization wrinkle. Although 50% of IT decision makers said that they were confident they knew what cloud services were being used in their enterprise, and again, I'd say 50% are wrong, employees can be using cloud services without knowledge of the company. Google Docs, Dropbox, social media, they may be storing stuff that is non-proprietary and non-confidential, stuff that you don't really care is out there. But when it comes time for litigation, if those employees are gone, you've lost access to that information because their password-protected accounts are gone with them. And you may not be able to produce that data, even though there may be records of it in your systems. Even if you can, some Facebook and some of the other social media services are not e-discovery friendly, and getting information back out is really hard. Then we have the international wrinkle. Cloud is ephemeral. Cloud services are everywhere. The data centers are everywhere. Things are moved around all over the place. Other countries do not see discovery the same way we do. And in fact, some countries would consider typical US discovery requests out of bounds. In Europe, for example, certain discovery requests might run afoul of the EU data protection laws. If you've got to export a lot of personally identifiable information from the EU to the US, there are data protection laws that prevent that from happening unless you jump through certain hoops. Similarly, and more specifically, France actually has a statute that blocks the use of US discovery to get information from French companies. And there is actually a case, the reference is in the materials, where this statute basically put a company on the horns of a dilemma. They could comply with the US court's order to produce material, or they could violate French law, and violate French law by doing so, or they could comply with French law and violate the US judge's order. If you have data spread across different jurisdictions, you may have to make a very difficult choice about your litigation. So given all of this, how do you contract for cloud services? We're going to talk about a lot of the differences between typical IT outsourcing and more typical cloud contracts. But the fundamental principle is that contracting with a cloud provider is different from contracting with a typical outsourcing service provider. An outsourcing service provider is bringing a bunch of people to provide service at your location for the most part. Even if you're getting some offshoring, all of that's being done at a known location by known people, and it's all funneling through your location. The services are very customized, and the deal is typically customized, and it's typically a fairly large deal. Cloud services, on the other hand, are benefiting from economies of scale. They are providing a single instance of their software, and in most cases, and running all of their customers through that single instance. Their data may be subject to contracts for additional storage, additional bandwidth. They're operating in the cloud, and they're partnering with other entities around the world to provide you with a service that is almost reminiscent of the IT black box. But what they're doing now is providing scalability and agility and a service that is a standard delivery model. And in order to take advantage of the cost savings and the agility in that standard business model, you have to accept the fact that you can't change a lot of things. So cloud providers tend to insist on their own contract template. In a typical outsourcing, the customers use their own template, frequently provided by some third-party advisor. Every deal is customized. You can negotiate almost everything. The service delivery is a customized solution. In cloud services, the provisions that are impacting uniformity and scalability of the cloud service are not negotiable. If you try to change those things, it destroys the business model. If you are a big enough customer, or if you have enough negotiating leverage, it's conceivable that you might be able to get a separate instance or some kind of different delivery model that doesn't break the cloud provider's model. But for the most part, for most customers, you're not going to be able to change the cloud provider's delivery model. The big thing in cloud services when it comes to contract modification is that it's much more like your typical, cloud providers tend to treat their contracts the same way they treat their software, in that they release new versions of their terms of service in the same way they release new versions of their software. And just like any other online service, you're bound to the current version of the terms of service. Well, that differs from your typical outsourcing contract where you would go through a change control and amendment process, and you would know and negotiate changes to your contract. One of the big differences between typical ITO and cloud services is service levels and service level credits. In a typical ITO, you have numerous service levels, and they're customized for the type of delivery model and the importance to the customer. And service level credits are typically based on a percentage of monthly revenue in the 5 to 15% of monthly revenue range, depending on the type of services. In the cloud, there tend to be very standardized service levels, and they tend to be very few, usually just availability. Might be one or two others depending on the nature of the service, but for the most part, as long as the service is available for you to use, that's the SLA that they're following. It's much more of a utility model, more like your electricity, your telephone. It's really that type of SLA model. Now, cloud services service level credits can be significant, even up to 100% of the monthly revenue, because they're so confident in their ability to deliver to the availability metric, which in many cases, if you do the calculations out, is not necessarily a great metric. One of the big things big differences that I alluded to was data location. In a typical outsourcing, customer knows exactly where the data is. In a cloud environment, the customer doesn't know where the data is. It's all over the place unless you specify. If you are subject to restrictions like PHI type restrictions, you may need to specify that your data has to stay in the continental US. That can be arranged. The larger cloud providers have data centers and are ready to comply with those sorts of things, but you need to look underneath the hood. You need to look underneath the covers and understand how they're providing the service so that you know that your data is staying where it is and it's not being moved around. Termination is another interesting difference between typical outsourcing and the cloud. Generally, in a more traditional outsourcing environment, the customer can terminate for a large variety of sins by the service provider. Generally, in cloud contracts, it's only for the cloud provider's material breach. Generally, in a typical outsourcing relationship, the supplier has more limited termination rights. In a cloud environment, again, because of the utility model and because of the number of entities using the cloud service, cloud service providers tend to have an acceptable use policy where breach of that acceptable use policy is grounds for the provider terminating or suspending the service. You can negotiate around this a little bit, particularly the acceptable use provision. You can generally get cloud providers to limit their right to suspend the service only to the extent necessary to deal with the breach of the AUP, but that's something that you need to talk with under those circumstances. In outsourcing, termination for convenience is generally a hot button conversation, and it generally involves payment of fairly significant termination charges. In the cloud, after the initial term, you basically, it's all paid for. So, on 30 to 90 days notice, depending on the service, and there may be some minor termination charges for certain non-standard deals, but generally it's very small. Then when you get to termination assistance, pulling out a typical outsourcing is hard. Switching providers means changing personnel. It can be very difficult and can last for as much as 12 months. Switching cloud service providers is just unplugging a connection and plugging into a different service provider. Tends to be pretty easy, and all you need to do is provide a copy of the data. So given all of that, what are some best practices for dealing with data in the cloud? When you're drafting your RFP or evaluating potential cloud providers or negotiating with your selected provider, know where your data is going to be stored. Request data center locations and consider including them in the contract. Suppliers are generally going to be reluctant to do that, except for the big suppliers who can have data centers that are of a size that they can handle it. But if it's reasonable for your data to be specified in a particular data center, you can probably arrange it. If it's appropriate, request geographic limits. Protect your data. Know what certifications the supplier has, know what audits you can use, and use the tools from the Cloud Security Alliance to evaluate your supplier's security. Ensure that you can use your data. A customer should have the right to access their data at all times. Make sure that it can be exported in a usable format, and the contract should specify any disengagement assistance requirements. Determine if your cloud provider can comply with data retention and destruction policies. Think about litigation. Talk to your general counsel and understand how the supplier's information might be used, what you're putting out there, and how that might need to be retained. Think about how you're going to comply with subpoena and e-discovery requirements. Again, talk to your in-house counsel and understand what notice of subpoenas could mean, whether the supplier can comply, and how you're going to negotiate for that in your contract. And finally, something that we haven't covered anywhere else is the concept of cyber liability insurance. It's a talk in its own right. It's an evolving area, but dealing with breaches and cyber liability is something to think about. It's something to talk with your in-house counsel about, talk with your insurance brokers about, and get an expert opinion on whether your contract needs cyber liability insurance or if your company should have it. When you're thinking about insurance, if you're just demanding that a supplier has insurance, then what you're doing is you're basically requiring the supplier to insure your risk. And if the supplier has to insure your risk, the supplier is going to get the maximum insurance possible to minimize their own risk, which means they're going to pass the cost of that insurance through in their rates. So you're paying for the maximum level of insurance, and it doesn't take into account your risk tolerance. That's an inefficient way to buy insurance. If you think about the type of risk you're willing to take and your risk profile and buy your own cyber liability insurance, you can make your cost most efficient in this area. That's not to say that you shouldn't require your providers to have insurance, but it's just one additional wrinkle to think about when you're thinking about insurance. So as I said, I'm from Infosys, and this is the product placement slide. Infosys is a cloud ecosystem integrator. We have currently about 190 engagements where we're doing professional services for the cloud. We have 12 different platforms on which we're providing cloud-based services. We have some industry leading IP in what we call the Cloud Ecosystem Hub, and if anyone wants to get in touch with me, I'll be happy to talk more about what that is and provide you with some information about it. And then we have an ecosystem of more than 30 partners that we work with to provide cloud services that we can integrate for our customers. With that, I'd like to thank you for your attention. I'll be happy to take questions now.